move just a little closer? Yes. Great, thanks. Good afternoon, Your Honors. Good morning, Your Honors. Donald Capro of the Nashville Bar, representing Piedmont Natural Gas Company. I'd like to reserve 3 minutes for rebuttal. Sometimes a chart helps illustrate something that is difficult to follow unless you can point to things, so I hope it helps Your Honors understand my argument. This case arises from the taking of a 4-acre easement to build a gas pipeline on a 221-acre property that was owned by Fontanel. Fontanel purchased the property in February of 2019, and just 2 months later, Piedmont approached them and said, we need a gas pipeline on your property, and there was no opposition to that, so by October of that same year, the easement was granted. And at that point, it was a fairly ordinary condemnation case. Fast forward 4 years as they're approaching trial, and that's when things got difficult and interesting, and I would submit raises a case of first impression. Because when the easement's been taken judicially and the pipeline then eventually is being built, the only issue for the court is what is the just compensation due the landowner? Fontanel was the landowner. Fontanel decided to do something I think it's never been done before that I've seen except for in Alabama, which is the case I have cited, which is to put on an expert, Mr. Gibson, to give only the before taking value of the property. And the method for determining just compensation requires a before taking value minus an after taking value equaling just compensation. And the way it's supposed to work is the expert who does the before taking value does their evaluation, comparable sales, analysis, discounts, different approaches. They do their 350-page report and come up with a number. And 2022, 2023, after this property was taken in October 2019, Mr. Gibson did a retrospective appraisal saying this property was worth $25.5 million as of the, before the easement was taken. And what makes that particularly interesting is that Fontanel, Mr. Farrell, the owner, purchased the property in February of 2019 for $14.5 million. So Mr. Gibson is saying that the before value 8 months later has gone up $11 million to $25.5 million. So Fontanel has the burden of proving the amount of just compensation. So this ordinary condemnation case became an extraordinary condemnation case because right before trial, Piedmont filed a motion in limine to exclude Mr. Gibson's testimony on the grounds that it was untrustworthy for him to give only half of the equation. And why, they said, would that be so pernicious for him to only give half the equation? They said because it would invite the jury to potentially use the before value of Mr. Gibson with the after value of Mr. Turner, and you can't compare, as I said on my thing, oranges and apples in that way.
Counsel, I have a counterfactual for you here in terms of thinking this through. Let's say a witness goes about this, what you say is the right way to do it.
Right.
In terms of providing the before taking value and after taking value. Dueling experts, they both do it, what you're saying the right way is. Is a jury free, and in the concern you're raising, mixing, blending, we shouldn't be doing that, that's improper. Can a jury look at it and say, you know what, I found more persuasive the expert's testimony as to the before taking value from expert A, but I found expert B more persuasive with regard to the after taking value. And can a jury make that determination? And you're saying we can't have blending, we can't have mixing. Is a jury not free to say, you know, maybe I thought one of the comparators wasn't very convincing for the before taking value of A, but I thought for the other guy or gal wasn't very convincing as to the after taking value?
Well, if Mr. Gibson had given an after taking value and come up with a just compensation number, and the jury considered both, then you'd have your battle of the experts. However, for a party to essentially say Mr. Gibson's before and Mr. Turner's after is okay for you to do, jury, which is exactly what happened here, even though there was no after value by Mr. Gibson. 6 jurisdictions would say, no, you cannot ever do that, because when Mr. Gibson is doing his value, he carries over all his assumptions, all his discounts, all his comparative property sales to B and adds one more variable, which is now we have a 4-acre easement.
How is the approach that I'm suggesting permissible, though, under your argument? How, if you can't blend, you can't mix. Even if a witness comes forward and does what you're saying is the right way to do it, it would seem to prevent the jury from taking from expert 1 the before taking value and taking the after taking value from expert 2. And how, it seems that I mean, is there something I'm missing in terms of that question or that circumstance? And it seems like you're taking that off the table for the jury, which strikes me as problematic, I have to say.
Well, I mean, because I'll just use an example. $5 minus €3 is not $2 or €2. You can't compare something that is incomparable. So to blend these two would violate the rules of expert testimony, which says it has to be a trustworthy opinion. And Mr. Gibson's opinion is not trustworthy because he never does the after. Now, your counterfactual argument
Here a little,
Huh?
we could take this and before taking value is the apples and after taking value is the oranges. And in terms of how we're thinking through, the other side is essentially saying, look, we agree with your after taking value, and we think your expert's right. We think the number. The only thing that's really being contested here is the before taking value.
Well, the irony of this case is Fontanel also absolutely trashed, saying it was laughable what Mr. Turner did on the before value, even though all of his foundation, all of his calculations, everything was carried over 100% to his after value, and all he did was say, now we have a 4-acre gas pipeline easement. And that 4 acres is only worth $98,000 because we have a 221-acre property. It's not doing that much damage to the value. So if you don't care, as the other 6 jurisdictions say, if you don't carry over everything, the foundation that creates this bucket of apples to the after value calculation, if you don't carry that over, then you're comparing literally oranges and apples, and you cannot compare valuations that are so dramatically done differently in this.
Is it really oranges and apples? Didn't Mr. Turner testify that his method was substantially similar to Mr. Gibson's?
No, he said they both use the sales comparison approach. That is not a method. That's just an approach. The method here that matters is A minus B equals C. What Mr. Gibson never did, that Mr. Turner did, was come up with a B. As a matter of fact, we tried to get the trial court to let Mr. Turner do a B for Mr. Gibson using all of his foundational analysis, and the court would not even let us do it. So you end up with, as the other 6 jurisdictions say, the strange, incredible, and unbelievable result of getting a verdict where a 4-acre easement, and this is what the jury did. The jury took the before of Mr. $25.5 million of Mr. Gibson, subtracted the after of Mr. Turner, and got this almost $14 million result for a property that was purchased 8 months before for $14.5 million, and then was sold on an auction for $11.5.
Was that $14 million purchase price, was it market value at that time? What didn't Mr. Gibson or someone testify that, maybe it was the purchaser, testify that it was under the value that he thought it was worth, and that property had gone up drastically since then?
Gone up drastically in 8 months? He
Yeah.
argued that what he really argued was that he put $8 million into it. But all he did was pay his mortgage, pay his insurance, and pay some architects to do some planning. Not a single thing was ever built on this property during that 8 months or even over the next 3 years. So the property never changed and never improved.
You emphasized that there are 6 other states that would not allow this. Are there any states that do?
No. And the other side was not able to point to one. The only thing they pointed to was a case in Texas that allowed this, but that case has been overturned by the case that we cite in Texas that says you can never blend these values because it's impossible to compare, and you end up with these strange results. So there's not one that allows this to happen. Now there is one case, all these cases involved the real counterfactual argument, where the other side won or lost below and said, well, we can justify what the jury did or what the jury should have done if we just blend the before of this guy with the after of this guy, and then it all works out. And all the courts say no. But in Alabama, the court threw out an expert, trial court threw an expert who only provided a before value.
How is that not an intrusion upon the right to a trial by jury, though? I mean, if a jury looks at it and says, you know what, I think the before taking value from expert 1 is bogus because they used X, Y, and Z comparator, and I just don't find that very convincing here, and I found the testimony about why it was problematic, persuasive. But the other guy or the other gal, you know, their testimony as to after taking value, I didn't find that one as convincing because something they used in terms of their comparison or their deductions or whatever it was. And how are we not intruding on the province of the jury with regard to making those determinations?
When you have a method for determining partial taking, and it's before taking minus after taking equals just compensation, and you allow an expert to only give the first one, then you are exceeding the bounds of what expert testimony can be allowed, because it's misleading to the jury to allow them to do something that they don't know they're not supposed to do, which is to compare two completely differently derived. That exceeds that because it's this is an analytical gap in its analysis, because the method is A minus B and he never did a B, but it's also unfair, undue prejudice, because you're not supposed to mislead a jury that you can do something that 6 other jurisdictions say you can never do and no jurisdiction says you can. And in Tennessee, we would submit the rules of evidence should have prevented this from happening.
Thank
Would
you.
you like me to take this down, Mr.? Okay. Just leave it or take? You can remove it. Okay, thank you.
May it please the court, Tom White. I'm with Tune Enterkin White here in Nashville. I represent the appellee who will make the argument today. I'll start by saying there's 2 reasons why there can't be any relief as the appellant has asked for. The first one is they don't address, even in the oral argument today, the testimony of the property owner. Tennessee statutes are very clear. A property owner can testify to the before and after value. As counsel said, that was the only issue here. The property owner in this case was a very experienced land use developer. His testimony about the before value was $26 million. The jury came back at $25,500,000. His testimony, the value afterwards, was $11,500,000. The jury came back at $11,600,000. Property owner's testimony was very credible. They don't address that. They deal with this other issue, which I think is really a little more academic about the appraisals, which I'll address here in a minute. The second issue, they didn't make a motion for a directed verdict. That eliminates sufficiency of the evidence, which I'll talk about also. But basically, the facts in the case are really undisputed. My client, Tim Farrell, had 25 years of experience doing investment in land use matters. He looked at the property of Fontanel, well-known place in Nashville, as an event venue. He hired John Haas, who'd been a land use planner on this property with the Barbara Mandel Group for like 10 years. He became involved. He hired this gentleman. He looked at it. He made a decision to invest in the property, went under contract in April of 18 for $14.5 million, closed in February the next year for $14,500,000. Testified that between that and the condemnation, he had invested, he thought it was average $8 million on land use experts, attorneys, other people that helped with what to get the property event ready, shovel ready, as he described it. That's his before value. His after value basically is his own opinion. His testimony is very clear. My opinion is afterwards was $11,500,000.
Counsel, can you address that $8 million? What was the increase that was contributed that added $8 million in the view of the property owner? And opposing counsel says he's essentially paying the mortgage. I mean, how is there an $8 million increase put into this property?
The testimony, Judge, by Mr. Farrell was hiring architects and land use experts. He gave the number, it wasn't questioned, to the tune of $8 million. But then he said if you added that to it, that in the 14 made it 22 or 23 million. He said, my opinion is, as the property owner, I thought it was worth $26 million. And I think that's something that the jury clearly identified with, but that was his rationale. During that period of time, he was trying to get it shovel-ready. And he made the comment, Judge, that when he bought the property, he thought it was a really good buy. He's an expert in this area. He thought he got a good buy when he bought it, spent this $8 million, and his opinion before was the $26 million. Now, the appraiser also had it at $25.5. So all I'm saying is that his testimony in front of the jury, which I think they clearly were credible to, had to do with what he'd done to invest in the property. But again, under Tennessee law, a lot of times a property owner will testify, and to be candid, a lot of times they really don't know what they're talking about. They're a property owner, they've got the right to testify. Here's somebody that had all the experience and all the credentials. That's how he got to the number. But basically, the after value, as I've commented about, was relatively clear. And if you juxtapose this to the person that testified for Piedmont, Jim Turner, he came in, he was aware that the client had paid $14.5 8 months earlier, under contract 18 months earlier, and he came in and evaluated it $3 million less right out of the box. He also went, and I want to clarify this because counsel was wrong when he said that the appraisers used different methodology. That is absolutely not the case. Not only did they use the same sales approach, Judge, but the testimony cited on page 17 of our brief, where their expert clearly said twice, I don't disagree with the methodology of the other gentleman. He said that twice. He didn't disagree with it. He disagreed with the number, but he never disagreed with the methodology. And I'll address that in a minute about other states and what they've done on this issue. And then Mr. Gibson testified. He's the regional counsel for Mid-South, incredibly qualified. Nobody questioned his expertise. He came in and said, not by my client, he'd been asked by an investor group, generally conservative, to give us an evaluation of the property. He came and did it in 2022 for $29 million. He took it back in time to the date of Tate, October of 19, said it was $25,500,000. That's the expert. He also confirmed me and the other appraiser used the exact same methodology. No dispute about that. He also testified on at least 2 occasions I've given only the before value in these cases. Now that's the numbers issue, but respectfully, the defendant in this case is the architect of their own agony, and I'll address that. It's really a tale of 2 cities. It's Duke in Charlotte. It's Piedmont here in Nashville. Here's what happened. There were several meetings at the property because my client was sensitive. He wanted to make sure they understood the impact of not being able to cross this easement. And so they had a meeting. Second meeting was December 10 out at the Fontanel property.
Counsel, I want to jump you ahead here a little bit in terms of piggybacking on a question that Judge Bennett was asking earlier. Are there any states that have looked at the issue that's being raised by opposing counsel and gone in a different direction? And so it looks, opposing counsel is essentially saying everybody who's thought about this question has said there's a problem in terms of presenting expert testimony in this type of way, dividing it out. Is there any jurisdiction that has agreed it's not a problem?
Judge Usman, I do not know of any. I think a number of the cases they cite are distinguishable, which I'll address in a minute, but I don't know of a site that does it. Basically, what they're saying, though, to cut to it, is there's other states that have authority on this issue. Let's apply it retroactively to a jury verdict in Tennessee. That's what we cut to right here. But when we get to the issue about the damages that are so important, one more time, if we give credence to the property owner and his own testimony, that more than justifies the jury verdict. But when they meet out there at the Fontanel site on December 10 of 2019, our client says, this easement is critical to my operation. On the other side of the easement is where Kid Rock performs, John Rich performs, Barbara Mandrell's 29,000 square foot log house is out there. All the activities, I've got to be able to get across this line on a regular basis. All the people there, judges, all the people are Nashville, Piedmont people. Bobby Garner, project manager, John Foster, we've got any number of different people, John Haas, who's basically our client with the land use planner. At that meeting, our client pours out what this issue would be. And Exhibit 8 spells out the response that Piedmont gave at that meeting. Piedmont basically says, Fontanel is a premier event destination and tourist attraction. The placement of the planned use gas easement across the property with easement restrictions could significantly impact the event, the operations, and future development plans. The purpose of this meeting is to discuss the potential impacts of the gas line on the normal operation of facilities and try to mitigate that. Fontanel receives potential event opportunities on a nearly daily basis. Basically, these opportunities require a near immediate response. Fontanel would like to seek pre-approval for
Council, I'm assuming you would not disagree that the key here is difference, right? The difference between the before value and the after value.
The only difference was the before value.
Well, but in terms of what the ultimate, what just compensation is the difference between those numbers. And why isn't opposing counsel correct when they essentially look and say, you shouldn't have allowed this expert to testify at trial court, because here we don't actually have a witness testifying as to difference. We have a witness that's only testifying as to value before rather than after. So we really don't have difference testimony.
Well, I'll answer it this way. It was your inquiry to other counsel. First, there's no Tennessee authority that requires that. It was repeatedly raised by Judge Brothers. There was no authority. And secondly, it's the province of the jury. In my opinion, it's clearly a jury issue. They can accept the testimony of one expert before, another one afterwards, the very thing you mentioned. There's absolutely nothing that a jury can't look at and consider. They considered that in this case, came up with the numbers. The other thing that we'll stress here is that Piedmont in that first meeting said, we'll put the line down 30 to 50 feet in the ground to make sure there's no problem in crossing this, et cetera. That's the way it went. And Piedmont said, we want you to do a Tier 1 and Tier 2 approach. Tier 1 was just superficial, Tier 2 where it's more invasive. A couple months later, they came back and said, oh, we don't really want to do that. Let's call it a blanket encroachment to come back and forth. That's the Nashville scene. Tammy Sturgis identified as the encroachment person, period, end of story. Enter the trial. Two years later, Elia Martin out of Charlotte says, we don't do blanket encroachments. After 2 years of listening to this, the lender basically said, that's all the fun we can stand. We're going to have to sell the property. It was an auction. The testimony is so telling. When Charlotte Duke comes to Nashville, John Foster, Ebony Wiggins, what do they say? Number one, look at the Piedmont guidelines. Basically, you don't even need our authority to come across this easement. That's incredulous. The jury was stunned for them to come in and say, you don't even need our permission after 2 years of all these documents back and forth. And the second thing they said, if you look at that Piedmont document, Exhibit 16, there's categories where it's very clear on its face. Private driveways, yes, you have to have written approval. Public, got to have approval. All-terrain vehicles, all of them require written approval. And they stood in front of a jury and made a comment that lost all credibility that you didn't even need our permission. They also said that basically Tammy Sturgis had no authority to do any encroachments, period, none. But a gentleman by the name of Tim Best did. Tim Best got on the stand. He didn't know anything about encroachments. He said, I went to the property one time for a grading permit. I don't remember who I met, what I did. I went there. That was their testimony. We subpoenaed the Piedmont people to trial. Bobby Garner, Stephen Fox. We basically subpoenaed those people. So I'll say at the end of the day, the issue about appraisers, in my opinion, is a totally secondary issue. A property owner in Tennessee has a right to testify to the before and after value. He absolutely did. He was believed. And with respect to the other issue, I want to comment. The standard of review in these cases is abuse of discretion. The other side has cited cases from different jurisdictions. Some of those can be distinguished. As an example, the Genge case out of Wisconsin, they placed a lot of emphasis on that. The Genge case says it might be a good idea to have before and after. However, if you have different methodologies, that's really a problem. We don't have that problem here. Both appraisers said same methodology over and over again. The Genge case was ultimately 15 years later modified by the Wisconsin Supreme Court when they said that same thing, and that is, if different methodologies might be a problem, if they're the same, it's not an issue. We've got the exact same methodology, and Mr. Caparella made the comment, not the same methodologies, totally wrong. I've read that. So basically, it's abuse of discretion in a jury trial. We all know it's almost like a common law writ of certiorari. Any material evidence to support the jury verdict, it stands. Any material evidence. Everything construed in favor of the opponent, et cetera, that's the jurisdiction. That's the law. And so one more time, what they're saying is there's out-of-state jurisdiction and authority, some of which can be distinguished, but we're urging this court to apply it retroactively to a jury verdict in Tennessee. It's the province of the jury to decide this case. They did. The case, in my opinion, had no credibility, period. And I think the jury looked at it and thought there was no credibility to the Piedmont position here. And they justifiably decided it wasn't punitive. There was just no credibility.
On the evidentiary issue, is that applying it to the jury verdict? I mean, isn't that a separate consideration with regard to on the evidentiary question? And so, rather than sufficiency.
It is, Judge. The same abuse of discretion on evidentiary calls by the trial judge. It's an abuse of discretion. How would the judge abuse discretion when there's no authority in Tennessee to support their position? And think about sufficiency of evidence for a minute. Aren't they really saying, I mean, this is first impression. That's a pseudonym for sufficiency of evidence. Because what they're saying is that Mr. Gibson wasn't to be believed by the jury because he didn't do before and after. The jury decided differently. They found him credible. He was at $25,500,000. The property owner was at 26. We didn't contest the after value that they put up there because basically we weren't going to waste the time and money. We're not Duke, we're not Piedmont. We weren't going to spend another $15,000 to get some appraiser to come in or even engage Mr. Gibson. We accepted their value. They're stuck with what their appraiser said. So respectfully, I'd submit one more time. I think the main issue is, does the property owner have a right to testify to before and after value in Tennessee? Unquestioned, he does, and that was credible, absolutely, totally credible. The position of Piedmont at trial here was just not credible on any basis. And one more time, with respect to the abuse of discretion, the jury verdict stands. I don't think there's any material evidence that does anything but support them. So I appreciate the court's courtesies today. Thank you for your time.
At this point in my career, I guess I can't talk without a chart, so if you don't mind, I'd like to bring it up.
You're only challenging, I understand what your challenge is. I'm not going to try and restate it. I understand what your challenge is. Is there any, how does the fact that we came up under the methodology that the jury used with a verdict of almost $14 million concerning 4 acres out of 220 something, that seems excessive.
Well, that's why the other 6 jurisdictions say when you do this type of blending, you end up with strange, unbelievable, and incredible results because you're not supposed to do this. I mean, and to answer your question that you asked him and asked me as well, Judge Usman, why should we not just leave this to the province of the jury? Well, this is supposed to be a fair market value calculation, and the fair market value calculation has a foundation that got him to the B, except for he never did a B. And the before value of Mr. Turner is supposed to be a fair market value calculation as well as this, and all they're adding is the jury amount. Excuse me, is the amount of the easement. So you can't leave the jury alone to just figure that out because because then you're going to be having them do something that that the jury instructions in this case say they're not supposed to do. The jury instructions say that they're supposed to look at the testimony of the people giving evidence as to valuation, and they're not supposed to stray from that and just pick something of their own. I'm not quoting it exactly, but essentially that's what the jury instruction says. It warns them against sort of going beyond the expert testimony.
They can't mix and match, though. I mean, is that instruction really telling them that you can't take from expert 1 before and take from expert 2 after?
In Tennessee, there is no precedent for this where somebody tried to just do it for us. So right now, we don't have a case that directly says that, but we think the rules of expert testimony that says this testimony can't have an analytical gap, and it has what could be a bigger gap than not doing the required after value. That's an analytical gap, and that is what the rules of expert testimony, Rule 702 and 703, should have convinced the trial court to not allow that to happen, because at the motion in limine, We specifically warned that that's what the other side was going to do, was to blend this, and the other side said, we accept this value. So of course that's what they were doing. And I have to leave you with this just to show the harmful error. When Mr. Turner was on the stand, he was asked, Mr. Turner, you're aware and your lawyers have told you that the court said you don't have to have the same appraiser for the before value as the after. You're aware of that, aren't you? And he says no. But then he said, but you'll take the law on that from Judge Brothers as opposed to your opinion. So they reinforced Judge Brothers' opinion about this is an issue of weight, and that was done over objection, by the way, and said, jury, do this, the blending. And you're not retroactively applying these other 6 jurisdictions. You're looking at these jurisdictions to inform that that Tennessee law of evidence says that this is an abuse of discretion.
Thank you very much.
Thank you.
Thanks to all of you. And I believe that concludes the court's docket today. Would you please recess court?